SJC-11826, Department of Children and Families, et al., v. Mother, et al.
Kelly, not Kill Kelly, correct?
It's Kill Kelly, Judge. Thank you.
Kill Kelly. Oh, there is an L there. You're right. You would know.
Good morning.
Thank you. You may proceed.
Good morning. Thank you. Thank you, Mr. Chief Justice. May it please the court. My name is Michael Kilkelly, and I represent the mother in this appeal, which is a report of questions regarding jurisdiction. The Suffolk and Probate and Family Court made a report as to whether the court has child custody jurisdiction under Chapter 209B or any other authority, excuse me, of a minor child who has been granted refugee status by the federal government, has resided in another state for more than 6 months, and has been placed with a Massachusetts agency in Massachusetts for less than 6 months. And if not, should the case proceed in the Massachusetts court, despite the lack of child custody jurisdiction?
Does the state refugee plan, does it arise from a specific legislative enactment that contemplates the creation of such a plan, or is the state refugee plan the product of an executive order?
I believe that the state refugee plan is the product of state executive order, but it complies with the federal refugee program, which is an act of Congress that would have created how to deal with unaccompanied refugee minors. So it does comply with federal requirements, and I think the federal government anticipated that the states would set up these programs. And the program is set up by the state. I believe it's totally funded by the federal government.
So is it your position that there is a state that could exercise jurisdiction?
Yes, in Texas, as the trial court judge originally thought, it's our contention that Texas is the home state of this child, the state where the child was for 2 years, and even for longer before then with her mother.
But then that seems to be questionable under its own statutes.
The department certainly in its brief raises a question. I certainly did not find any Texas case law that really said one way or another. It comes down to the definition of a person.
But you would agree that at the time of this, at the time, the child was essentially in the custody of is it ORR?
Correct.
Federal agency.
Federal agency.
And at least as I understand it, it's the federal agency that consents to suit with respect to the child.
Correct.
And
places the child in the state.
And unless the federal agency were to consent to the suit in the Texas state courts, would that, how would you get?
There's some element of that, Judge, but what the federal law contemplates is that when the child is placed in the state program, that the state applies for custody pursuant to applicable state law.
Right, but...
And the applicable state law is the Child Custody Jurisdiction Act, which again is also a creation of federal law because we have the Parental Kidnapping
Right, I know that,
Act.
but I'm still on the point of you say Texas was an appropriate home state, and I'm just wondering, without ORR saying, yes, we consent to having you, Texas state courts, take this, how do you get the child there?
I don't think you have to get the child
I
there.
mean, how do you, I don't mean physically.
Right.
How do you get the Texas state court to have jurisdiction over her?
Well, I think you apply. You file whatever case Texas may decline. Texas may say, we don't think we're the appropriate state, but I think at least the statutes require that Texas be asked initially because the child is from Texas. The child lived in Texas.
Well, but child is an alien.
Child.
And so does it, as
no,
such, is there really a home state?
Well, I think in all other contexts there is. If the child had lived in Massachusetts and been taken custody by DCF, Massachusetts would be the home state. If the Texas child welfare authorities had taken custody of the child, then there would have been a equivalent of a care and protection case in Texas with proper
But the fact of the matter
jurisdiction.
is, it was ORR which took custody of the
Correct.
child, and why does not Section 1101, and the feds have very long statute numbers, 1101A27, small 3, 1,
I think that's an I.
is that an I? I
don't
can't
know.
tell whether it's an
What
I
it
or a 1.
is.
In any event,
Yeah.
why does that not say that once ORR has it, under federal law, ORR can essentially say, we consent to having this be heard in only one state, which is the state where the child has been transferred by us, which in this case would be Massachusetts. Why is that not a sensible interpretation of what the feds,
Because
the federal statute intended?
There's other parts of that, but what the statute says and what the regulations say is that the state where the child is placed goes to get custody under the applicable state law that applies.
Why do you
So
read
it
it so
doesn't-
broadly? Can you read it only to say, seek custody under those laws I mean, it could have a narrower, it doesn't necessarily have to, but it could have a narrower interpretation that's consistent with the law of that state as to how you get custody. Not the UCCJA, but that state's laws
It,
within the state.
it could, Judge, I suppose, but I think my argument is that it's the entirety of the state custody.
I
It
understand
doesn't
your
really
argument.
make
I was
sense
just suggesting there might be another
I don't
view.
think it makes,
Yeah.
certainly, I don't think it makes sense otherwise to carve out something where, and again, I think by including the Child Custody Jurisdiction Act in this, I think we have not just the immigration laws, but we also have the child custody laws that Congress has instructed the states and the courts to follow. My basic argument today is that due process for this child and for this mother is followed and is upheld when the home state of the child considers the custody of
Well,
the
what
child.
What happens if we agree with you? What happens to this child?
Well, this particular child happens to turn 18 today and becomes an adult, so nothing will happen to
Well,
this
let's say
particular
she was
child.
turning 15
If she was
today.
turning 15, then the Commonwealth would have to seek custody in a Texas court. Texas court may say, particularly given the passage of time, that they
you're
don't want to
telling-
have custody, but if
I'm asking you a
initially...
different question. I'm asking you a very practical question.
Yes, Judge.
Of what happens to the child who is subject to this kind of proceeding, not the procedural
understand.
maneuvering that will go on around the child. What would happen?
Some kind of child custody petition would be filed in the appropriate Texas court, as happens every day when a child moves from one state to another, has been in this state less than 6 months.
Okay, so
custody
so
case
the
has to be
child
filed in the child's home
would
state.
stay here
Child would stay
in
here
Massachusetts
in
until
Massachusetts until
what happens?
the Texas court could give custody to DCF. The Texas court could say custody is better determined in Massachusetts. The child still
Would the
remains here.
Texas court give custody back to the mother?
The Texas court could give custody
Even
back to the
How?
mother. The Massachusetts court could have given custody to the mother.
So what if DCF had waited 6 months after February 25th, 2014, when the child arrived here? If it waited 6 months and then filed the petition here?
Perhaps the jurisdiction element would have been satisfied, but the federal law requires the state to apply for custody within 30 days. So
Well, it
they would
didn't-
have violated the federal law
Why didn't it require Texas to apply?
because the child remained in ORR.
In
During
the
the
custody
time.
of ORR?
She was in the Texas program after she had been placed with ORR. She was not placed in a state program. She remained in the care of ORR.
It was,
in
so
care
the
of
Shiloh was really an agent of ORR.
Correct,
It wasn't a Texas state program.
correct.
Is Texas even one of the states that
Doesn't appear to be. I'm not sure what the 15 states are, but Texas doesn't appear to be one of them that has this kind of program.
So what meaning do you give to that statute which Justice Botsford and I have referenced, the 1101A? What meaning does it have?
It means that the ORR is placing the child in Massachusetts with the Department of Children and Families, that the Department of Children and Families is thereby authorized to seek custody of that child pursuant to the laws of Massachusetts.
Right, but that provision says no juvenile court, I'm not quoting it, no juvenile court has jurisdiction to determine the custody of an alien in the custody of the Secretary of HHS unless, in this case, she specifically consents to the jurisdiction. So what meaning do we give to her specifically consenting to the jurisdiction of a state court with regard to the issue of custody?
Well, I would argue that it gives the authority to the Department of Children and Families to seek custody of the child in the court that is appropriate.
right, but you don't
within
have
the
that in
state law.
Texas. But you don't have that in Texas, right?
I think that the court in Texas would be the home state for this child, and so would have the jurisdiction over this child and would be able to determine.
I thought you just explained to me that Texas was not the appropriate place for custody to be determined because the child had not been placed in the custody, temporary or otherwise, of a Texas agency.
The state of Texas didn't have custody of the child. Texas child welfare authorities were not involved with this child because the child was in ORR, was not in an equivalent state program. The child was for 2 years in the care of ORR, in the care of the federal agency.
So she was essentially a ward of the federal government.
Correct.
But doesn't it limit the federal government? You're saying the federal government is limited to seeking child custody jurisdiction in Texas.
I'm suggesting that in this
And even though the program
case,
that they think is appropriate for the child is not in Texas,
correct.
but is someplace far removed from Texas.
Correct.
But you're saying somehow that this has the non-obvious effect of limiting the federal government's choices.
To where the court case must be, not to where the child is placed. The child can still
Child
be
can
placed in Massachusetts.
But custody will be within the state of Texas?
Within a Texas court as the child's home state.
Does that seem odd to you?
It's not from my client's point of view. My client lives in Texas.
Well, suppose they
Her
put
child
in a
is taken
program-
away
suppose-
from her.
Suppose instead of putting it in Texas, let's just say the ORR had the child in a program in Tennessee and maintained custody in that sense itself in
Yes.
Tennessee, and then decided, well, the long-term care of this child is best in Massachusetts because there are these programs and so forth. So we want custody to be determined by Massachusetts courts. You're saying no, you have to go to Tennessee.
At least initially, I would suggest that Tennessee in that kind of instance would most likely decline jurisdiction because they have no.
So you're supposed to go. So it's not really the federal government, federal agency having the ability to consent to a particular state. It's sort of wherever it is that they first place the child and maintain.
Oh, it's where the child is for 6 months.
And that then
before
limits
being
them. They no
placed in
longer
a
have the
state
ability
program.
to choose
They can
beyond that.
still choose where the state is that the child is placed, what state
But that
program
doesn't seem
the
to
child
be
is
in
placed
keeping with the language of the statute that Justices Botsford and Chief Justice Gantz have been
I
quoting.
suggest there's other language in the statute which suggests that the custody of the child should be determined pursuant to the child custody laws. Congress has set out specifically child custody laws so that the home state of the child is, otherwise you have a situation like in this case where the child is removed essentially from my client who lives in Texas, is placed in a hospital there in Texas where my client can have some contact with her, and now the child is placed in Massachusetts. Now my client has to come all the way to Massachusetts to assert her right to custody of this child. I'm not sure that that result makes sense when my client and the child resided in Texas the whole time.
What's the closest state to Texas that is partnering with the federal government in this program?
I'm not sure, Judge. I don't know exactly which 15 states partner, but
All right, thank you.
thank you, Judge.
Good morning, Your Honors. My name is Jean Kaiser, and I represent the child in this case. I'll be arguing for 7 minutes, and counsel for the Department of Children and Families will argue for 8 minutes. Here, Your Honors, the probate court could properly assert jurisdiction because the plain language of its jurisdictional statute, the purpose of that statute, and the interaction between state and federal immigration law all establish that jurisdiction exists. And in fact, to find otherwise would thwart the complicated state and federal scheme that provides protection for children in the care of the Office for Refugee Resettlement, and essentially render, as the court has commented, the system for caring for child victims of human trafficking and sexual exploitation unworkable.
Under what statutory section do you say Massachusetts could have exercised jurisdiction?
Actually, there are two sections. Section 2 under Chapter 209, Section 2B. A2 and 4 of the statute both provide for jurisdiction. And I think the problem with the appellant's argument is that it reads the statute too narrowly. It is absolutely true that the general rule is that jurisdiction will be based on the child's home state. But the statute, Sections 2 and 4 specifically, contemplate that there are times when a child won't have a home state. And this is exactly such a case. Whether you look at Massachusetts' definition of home state or the Texas definition of home state, it's clear that the child was not, her home state was not Texas at the time she came to Massachusetts.
And why is that?
That's because home state is a defined term. A child has to be living with, it's not just that the child is physically present in the state, she has to be living with a parent or a person acting as a parent. And person acting as a parent is further defined as someone who has either has been awarded custody of the child or claims legal right of custody. Now here...
But does ORR qualify as a parent or person acting as a parent?
Arguably, it does under Massachusetts law, although Texas law, under Massachusetts law, it includes an authorized social services agency, but Texas law does not have that provision. It just says person acting as a parent, which seems to indicate only a natural person meets that definition under Texas law. But whether or not you could even implicitly read in that ORR could be a person acting as a parent, ORR is not physically located in Texas. It's a federal agency, and the child was not living with ORR. The child was essentially placed in Texas by ORR until such time as the ORR identified an unaccompanied refugee minor program for the child to be more permanently placed in. So in essence, the child was in a kind of analogously a federal foster care where ORR was charged with making all decisions about the child's well-being until such time as it placed her in a state program. At that time, and this is where the statute that the court referred to, 11001, with all of its numbers and letters, that's when that kicks in, because at that point, the federal government is consenting to jurisdiction here in Massachusetts, not in Texas. And also we need to look at.
But let's assume, I mean, this case is now, if we decide it, it's moot. It'll be moot as it's moot today. So if you're right, then it applies only where Texas is the home state. It may not apply where Arizona or New Mexico is the home state.
No, Your Honor, I don't think that's true, because it's not a question of whether I think the issue here is Texas was not the home state, even if you look at the definition under Massachusetts law. Section A2 definitely contemplates a situation where a child doesn't have a home state. And in such instances where there is no true home state for the child, if it is in the best interests of the child, and specifically if the child and another contestant are located in the Commonwealth, and substantial information about that child is located in the Commonwealth, then the court does have jurisdiction.
Okay, but now I'm perhaps confused. You had your footnote, not sure it was your footnote, but the footnote which says, or the argument that basically says it's only because of the Texas narrow definition that Texas is not the home state. You're making a different argument?
I would suggest, Your Honor, and this is it's tough to talk about, but under Section A2, the court, if under Massachusetts law the child has no home state, the Massachusetts definition of home state, then the court can take jurisdiction if it is in the best interests of the child. Under Section A4, if no other state has jurisdiction in accord with Sections A1, 2, and 3 of the Massachusetts statute, then again, Massachusetts can accept jurisdiction.
I guess where I'm confused is, are you saying that all ORR children have no home state, or only that this particular child has no home state?
This particular child had no home state, and it may be true that many ORR children would not have a home state because many of them would be coming from places not in the United States. But I don't think it would be an atypical result, although there could be a...
Well, if you limit the class to aliens, then under this 1101, I mean, sort of ORR gets to pick where you can do this, seems to me.
That's correct, Your Honor, and that makes sense in the way the whole federal scheme is set up, because the federal government does assume responsibility for these children and then locates the place in the United States that would best serve their needs. So in this particular instance, the ORR felt that the program here in Massachusetts would be best suited to serve the child's needs.
She turns 18 today, I know that. Will she stay at the program that she's in, or does she leave it?
My understanding is that, yes, her stay there can be prolonged, even though she's reached 18.
But could she, I think it can until she's 22 or something like that.
Sure.
But could she just say, sayonara, I'm leaving because now I'm not a child anymore?
That's a good question, Your Honor, and I'm not sure of the answer to that. I think she would
to this
be...
case, I just was interested.
Yeah.
Are there deportation consequences of making that decision?
Well, the child's immigration status is a whole separate issue and is the subject of other proceedings that are going on as we speak.
All right, thank you.
Thank you.
May it please the Court, Brian Pariser for the Department of Children and Families. To go back to Justice Botsford's question just before it's lost, if the Court was curious, the child can remain in the Department's program until she's age 22, either voluntarily or through an additional court order. So the Department can offer, as it does frequently to any child who's been receiving services, the opportunity to voluntarily re-up with the Department for an additional several years, or in the event that the child is deemed to be incompetent to make that decision, could file a guardianship petition on behalf of a mentally ill adult. And that would be another probate court proceeding. There are really, just to bring this back to the jurisdictional question, there are 3 reasons that Texas cannot be considered the home state for this child. The first one, as the Department describes in its brief, is the Texas statute itself. The Texas statute itself requires that the party exercising parental control, acting as a parent in Texas, claim custody under the laws of that state. Actually, the statute says of this state, referring to Texas. And ORR, there is no dispute, was the alleged person acting as a parent. In the event that this court were to find that ORR is a person acting as a parent, there is no argument that ORR claimed custody of this child under Texas law. ORR claimed custody of the child under federal law and exercised custody of the child under the acts of Congress, not under the Texas law. So under the Texas statute, ORR could not qualify as a person acting as a parent, and therefore that would remove this child from the jurisdiction of the Texas state courts. I will also add that I did quickly look at the language of the California statute, which mirrors the Texas statute in this respect.
Can I ask you this, though? Do you have to, I just was wondering whether under our own definition of person acting in the, whatever it is, person acting in the place of a parent, or
Yes.
It says it's a person, it can be an authorized social service agency, and it has to show that it was awarded custody of the child or claims a legal right to custody, right?
And that's a key distinction. You'll
Right,
note
right.
that
So that's my question, is whether under our own statute you would have the same result. Do you have to, this is back to Chief Justice Gantz's question, do we have to depend on Texas law for
I don't
this?
think you do, and I did have two other reasons that we don't need to rely on Texas law. That was merely the first one. Our statute does not say under the laws of this state, unlike Texas's, and it does expressly include a social service agency. The department is not making the argument or representation that ORR is in fact a social service agency. That point may be arguable. I don't know that the United States government would agree with that.
I was thinking about Shiloh, maybe.
Shiloh is a facility where the child was held, and I believe the appropriate way of viewing her placement at Shiloh is much like when the Department of Children and Families receives custody of a child and places the child for care or treatment at a residential facility in Massachusetts. That facility is an agent. It's a service provider on behalf of the custodian.
So
Shiloh is similar.
The Shiloh was acting under contract with the federal government, essentially?
That's my understanding. But ORR was the entity that had legal responsibility for the care and custody of that child, and in doing so, placed the child at Shiloh. I think my sister's right by way of analogy to some sort of federal foster care system. Beyond the Texas statute, our own statute, it is perfectly readable to assume that this child does not have a home state. The child is an alien, does not have a right to be in the United States, is not arguably not a resident of Texas, but was taken into the custody of the federal government, and thereafter can only reside in a place authorized by the federal government. I agree with my sister that the federal government is not a contestant that is present in Texas, but it's not a resident of Texas, ORR. It is the federal government, and it exercises authority in its own right. And the third reason that would apply to all states and would not require reliance on the Texas statute, even though many statutes are similarly written, is simply that the Texas court could not exercise jurisdiction and could not rule on this because the Secretary of Health and Human Services never consented to a Texas court exercising that jurisdiction. So even under Texas law, under our law, under federal law, that court has no jurisdiction, according to Congress at least, has no jurisdiction unless the Secretary consents to that jurisdiction. That never happened in this case, and arguably it will never happen in any case where ORR makes the decision to place the child in Massachusetts and consent to the Massachusetts court exercising jurisdiction. That's really the simple answer. So for all of those reasons...
So if that's the case, basically ORR can choose the home state. I mean, can choose the state where the matter will be decided.
And the Commonwealth would argue that that was Congress's intent.
What if Massachusetts didn't want to exercise jurisdiction? What could it do?
Well, it could have a discussion with the federal government. Remember, the state is partnering with the federal government as one of those 15 states to care for these children. And before ORR makes a determination about where to place a child in which of those states, ORR is having discussions with those states, is making some determination about which state could best serve that child. And I suppose if for some reason Massachusetts felt it was not an appropriate state, it would be an opportune time for Massachusetts to have that discussion with ORR.
When did the state enter this partnership exactly?
I don't recall exactly. This program has been going on for some time.
Like 5 years?
The Unaccompanied Refugee Minor program has its genesis originally, I believe, back in the 1980s. I'm guessing at that, please don't quote me, but it did start with the refugee problem from Southeast Asian children. That's when the Unaccompanied Refugee Minor, it's been expanded to include other children, but that is when the program began.
Do you think that Massachusetts became a partner back then?
I could report that to the court. I don't have the exact date.
So taking your third argument, it's essentially a federal preemption argument. That regardless of what the state
clearly interrelated
regardless
with that, yes.
of what the state may say should happen, we, the federal government, say that when a child is in ORR custody, the Secretary of HHS determines where the matter shall be adjudicated.
Yes.
So, so the theory is that that's also state law because we would then be adopting federal preemption as part of our state law.
Well, I'm not sure it's exactly federal preemption. I mean, you could do that, but under our own definition, if we can't, under our definition of home state, if there is no home state because our own language doesn't fit this set of facts, then under 2A2 or 4, you get to the same place without...
I think so, and that's why I hedged a little bit, Chief Justice Gantz. I don't know that it's expressly it's related to a preemption argument. However, just a straight reading of the Commonwealth statute by itself, the question is does it appear under either 2 or 4? Does it appear that another state is the home state? I think that the probate court judge can look around and can say, there's no other state that the Secretary has consented to. There are also these wording of other states' statutes. It does not appear that any other state has the authority to exercise jurisdiction, and therefore, because the federal government has chosen to place the child here, because, and remember, the Massachusetts statute is also interesting in that under Section 2, it talks about evidence regarding the present and future care of the child, not the past care of the child. So since it's presumably where the child is going to be residing, is going to be receiving that care that ORR determined was appropriate for the child, for those reasons, it would be best for Massachusetts to exercise jurisdiction when it does not appear that another state could.
Is there anything in the plan itself that addresses the problem of this huge distance gap between the mother and the child's location, the mother being in Texas and the...
In the plan, meaning? I'm not sure which plan.
The state refugee plan.
Well, I don't know that there isn't particularly in that plan. That is essentially the working document for running the program between the state and the federal government. I'm not sure whether there's anything in regard to that. What I will say is that the mother obviously has had the opportunity to work with ORR. There was an administrative hearing you'll see the record had. There was an opportunity for a hearing and for a consideration. You also know, of course, that she's kept tabs of where the child is because she has now moved to Massachusetts. And that may solve that problem for this child, certainly. But I'm not sure that there's anything that would address. I mean, a determination was made by the federal government, essentially, that the child could not live with her. That's a quirk of this case, only because in this case, the mother happened to be in Texas. In many of these cases, they are more classically unaccompanied, and their parents probably do not even reside in the country. In most cases, in this case, the mother happens to reside here.
What's the difference between Section 2A2 and 2A4?
Within our statute?
Yeah, within our statute. Who are they reaching that's different?
I don't know that there is. Both require, again, that it appears no other state could exercise jurisdiction. So that's the first part. In Section 2, then, The only question is about contestants, right? Section 2 talks about that there needs to be a contestant in addition to the child. So it could be that that section is really trying to reach what would more classically be, say, divorce cases with parents and living in different states. One contestant needs to reside here. 4 does not require the presence of a contestant in Massachusetts. It merely requires that no other state could, sort of a catch-all, no other state could, and it would be in the child's best interest to have the matter adjudicated here.
Thank you.
Thank you.
Thank you.
All right.